others against Morris and Lower in place of Gwyn-Jones.
Yes, Mr. Trigger.
Morning, Lord. Morning, Lady. As you know, I appear with Mr. Sterling for the appellants, while Messrs. Morris and Davis, the executors of the late Mr. Gwyn-Jones. To all intents and purposes, I'm representing Foxbase. The reasons for that are historical and don't matter. It's easier to think of it that way. And then friend Mr. Humphrey appears with Mr. Aiden, the respondent. As you know, my case in a nutshell is that if Mr. Barton has any claim to remuneration in the circumstances of this case, and he doesn't, but if he does, it could only ever be on the basis of an implied term to that effect in the oral agreement that was reached at the end of July 2013. But in the light of the subsistence of that agreement, unjust enrichment has nothing to do with it. And the Court of Appeal were wrong in my submission to hold that the absence of an express agreement about remuneration, if the price for which Ash House was sold was less than 6.5 million, meant that somehow an unjust enrichment claim was available. But on the facts, as I say, no term for remuneration can be implied, and the Court of Appeal, insofar as they were suggesting that one could be implied, were wrong about that too in my submission. Ultimately, this is just a case of a party who made what turned out to be a bad bargain, and the Court of Appeal impermissibly rewrote that bargain because they seem to have reached the view that it would be unjust to hold Mr. Barton to the deal that he did. But I submit that's the deal he did, and he should be held to it. Curiously, as I read my learned friend's printed case, he now seems almost, I think, to agree that he can only ever succeed by means of a contractual claim rather than unjust enrichment. Because despite having disavowed any reliance on an implied term at first instance, he now says that a term should be implied, entitling Mr. Barton to reasonable remuneration, even if the sale price was less than 6.5 million. Indeed, I think he goes further and says he can get home by simply construing or interpreting the express terms of the agreement without the implication of any term. And despite his grounds of appeal to the Court of Appeal, all having been firmly targeted on a claim in unjust enrichment, the unjust enrichment claim now seems to be my learned friend's alternative or even second alternative case after interpretation and implied terms. And if I've understood it, he's now saying that the unjust enrichment claim succeeds somehow because the introduction agreement requires it. That's the way he puts it in his case. Rather than, as before, that unjust enrichment is available because the introduction agreement is silent about it. To be clear, Lords and Lady, I'm not going to argue that my learned friend shouldn't be permitted to argue his case in this way. If he wants to run implied terms, he can run implied terms as far as I'm concerned, but he won't succeed however he chooses to put it. But I do say that particularly the way my learned friend has now addressed it means that the right way to approach this case is, as I did in my written case, which is, this is subject to your lordships. I propose to go through by looking first at what the parties expressly agreed, secondly at whether there's an implied term, and thirdly whether unjust enrichment provides any alternative claim. So without further ado, express agreement. The agreement in this case was an oral agreement. The interpretation of an oral agreement is a matter of fact, or perhaps inference from primary fact, and not a matter of law, or at least there may be an element of law involved, but it's much more of a matter of fact than it would be if one were construing a written agreement. The judge's findings about the meaning and effect of the agreement, where it's an oral agreement, in my submission, are critical. So if I could ask the court, please, to look at some of the judgment, I know, of course, you've looked at it, but if I could just draw your attention to one or two passages, just to be clear about what the judge actually found. Could the court please start by looking at page 215 of the electronic bundle, paragraph 12 of the judgment. This is just to see the way in which the case was being run at first instance. So the appellant, that was Mr. Barton, his primary case was that Foxpace was liable to him in contract, the terms being that in the event that Mr. Barton introduced a party that purchased Nash House from Foxpace, Foxpace would pay him 1.2 million. In other words, the primary claim was that 1.2 million would be paid regardless of the price for which Nash House was sold. That was his primary case, contractual. Moving over the page, paragraphs 13 and 14 are about when that contract was alleged to be concluded, and we don't need to focus on those for the moment, paragraph 15. Paragraph 16 then addresses the respondent's case, Foxpace's case, in effect. And you'll see from 16A and B that our case was no terms of the contract were agreed, so there was no contract. Parties simply weren't ad idem, didn't reach a contractual agreement at all, or B, if they did, it was all subject to contract, so there was no binding contract. But then the alternative case is at C. If a contract was reached between the parties, the terms of the contract were that Mr. Barton would be paid 1.2 million if, but only if, Nash House sold for 6.5 million, or alternatively at least 6.5 million. And since the property sold for 6 million, no liability therefore arises. So that was our alternative case. I say our, obviously, I wasn't there at that stage. My own friend Mr. Sterling was. But that's what was being said on behalf of Foxpace at that point. And the whole point of that, and this is the crucial point, the whole point of that was that it was being said, if there's a contract, then you only get paid under it if the price was 6.5 million or above. There was no liability arises if that was the agreement. And can I just address head on at this point the if but only if point? Because obviously that was something which the Court of Appeal were exercised about. In my submission, the words but only if add nothing to this argument and to what the judge found. And if one thinks about it, even if the judge had found that the agreement was 1.2 million if but only if Nash House sold for 6.5 million, my learned friend would still have an argument that all that does is say he'd be paid 1.2 million if but only if the price of Nash House was 6.5 million or above. He could still say it doesn't deal with the situation or it doesn't preclude an agreement for remuneration if the purchase price of Nash House was less than 6.5 million. All it says is 1.2 million in that situation. It doesn't say anything about anything else. So if but only if, in my submission, isn't the point. It doesn't add anything. As a matter of English, if Nash House sold is the same, but if but only if Nash House sold. What mattered was that this argument, the whole point of this argument, was that if the property sold for less than 6.5 million, there would be no liability in contract. And then paragraph 17, the court will see that the unjust enrichment claim arose in response. It was the reply point on my learned friend Mr. Pumfret's side, and the way, as I understand it, unjust enrichment originally came about was that it was addressed to the points in paragraph 16A and B. So it was saying if there's no agreement, if Foxpace is right that there's no contract at all, then I've got a claim in unjust enrichment. it wasn't, I think, originally intended to cover C, which is where there is a claim in contract. But that's the way, of course, it then went. And the judge raised the Costello point and said, can you still have a claim in unjust enrichment, even if there is a claim?
The words of paragraph 17 are perfectly general and appear to include alternative C.
It might, all I'm saying, I'm not saying that the judge necessarily viewed it in that way. All I'm saying is, as I understand it, that was the logic that led to unjust enrichment coming into this case at all. And I'm not going to take you through all the skeleton arguments and so on, but if one reads those, one can see that that's the way it originally came about. Doesn't matter, I agree. But that was the genesis, as it were, of the unjust enrichment point. Then, moving on, the judge summarises all the evidence, as you've seen, for a number of pages, and then at page 223 of the electronic bundle, paragraph 60 and so on, he's summarising the evidence given by the various witnesses, starting with Mr. Barton, and at paragraph 108 on page 230, the court will see that the judge sets out a part of Mr. Rook's witness statement. Mr. Rook was Mr. Gwyn-Jones's assistant, so to all intents and purposes acting for Foxpace here. And in his witness statement, paragraph 17, you'll say, he said in about mid to late July 2013, Mr. Barton broached the idea with me over the telephone that if Weston ultimately purchased the property for 6.5 million plus VAT, then he might be paid 1.2 million out of the proceeds of sale, and so on. I'm not going to read out the rest of that evidence, but that was the witness statement evidence from Mr. Rook. And then
So Weston was already known to both parties as a potential purchaser?
Well,
according to this...
according to that evidence...
But that part of the evidence wasn't accepted.
No, and I think that was... that Mr. Rook, when he wrote that witness statement, was obviously sort of conflating what later happened. So it would in fact have been broaching the idea that if he found a purchaser for 6.5 million, but it later turned out to be Weston. The Lordship's quite
That's much, yes, and even Mr. We'll look at paragraph 19.
Yes, indeed, Lord. So then one gets, and I'm going to move through fairly quickly just because of the time, but if one then goes to paragraph 119 on page 232, the judge is here dealing with... I'm sorry, my Lord, I should have taken you first to paragraph 116 on page 231. This is Mr. Morris's evidence. Mr. Morris was the solicitor acting for Foxpace, so still, as it were, on my side. And paragraph 116 is paragraph 11 of his witness statement. And Mr. Morris is saying, I was informed by Mr. Rook that the prospective deal involved the sale of the property to Weston at a price of 6.5 million, with a payment of 1.2 million being made to Barton if and only if that price or higher was achieved. It was made clear to me that Mr. Barton would receive nothing if the property was sold to Weston for less than 6.5. So that was Mr. Morris's evidence. He was saying Mr. Rook had told him that Mr. Barton had in effect agreed that if it was sold for less than 6.5 million, he'd get nothing. At paragraph 119, which is where I was going a moment ago, the judge recorded that at the end of his cross-examination, Mr. Morris said he recalled Mr. Rook saying that Mr. Barton would receive nothing if the price received was less than 6.5 million. He said that this did not strike him as strange. I point that out just because it explains the comment that the judge makes a bit later on, strange point. Then in paragraph 123 onwards at the bottom of that page, the judge deals with the submissions, one has to be slightly careful with this judgment. It's very well structured judgment, but the judge sets out the submissions, and sometimes one forgets that they're submissions and thinks that he might actually be making findings. So one has to go by the headings. So he's setting out the submissions there, and then on page 234, paragraph 133, he discusses the evidence, and on page 235 at the top, paragraph 134, he makes the finding about Mr. Barton, same as a friend's client, that he's an unreliable witness. And one sees at the end of that paragraph that he says, whilst I've no reason to doubt that Mr. Barton genuinely believes in the merits of his own case, I can't place great weight on his evidence as to what took place in the various discussions. But then, so far as Mr. Rook is concerned...
What was the significant change in his case from that pleaded to that he now relied on? What was that shift that the judge is referring to there?
Oh, that was, my lady, that he had said originally that the agreement was reached at the Baker Street meeting. And so he'd alleged that there was a meeting in a cafe, I think, in Baker Street, at which it had been agreed. I'm just looking for the passage in the judgment that deals with this, which it was said it had been agreed at that point that if the property was sold.
And that was the pleaded case.
And that was the originally pleaded case, but of course there weren't pleadings in this action. The pleadings were in the other county court claim that was ongoing and was then stayed pending this action. The procedural history is all horribly confused. But there was a pleading from Mr. Barton in which he had said that the agreement was reached at the Baker Street meeting, but he couldn't then explain why he hadn't corrected that later when he'd seen from the various emails that that couldn't be the case. Probably slightly garbled that, maybe, but that's the essence of it. And I think that was one of the factors that led the judge to find that Mr. Barton was unreliable.
But he did maintain throughout that the agreement had been that he would get the 1.2 million regardless of the price at which Weston bought the property.
He did, but he said he changed that to say that agreement came later.
Right.
I mean, the judge found all the witnesses unreliable, yes, as far as I can see, and he just had to piece together what he thought was the best that he could out of their different accounts.
Up to a point, my lord, that's right, but I was just going to show you what he said about Mr. Rook, because in my submission this is relevant to what the Court of Appeal later say. In paragraph 138, he says the witness statement signed by Mr. Rook is like that signed by Mr. Gwyn-Jones, somewhat overstated in its tone and dismissal of the merits. However, I found Mr. Rook to be straightforward in giving evidence in the witness box. He avoided the hyperbole of his witness statement and gave evidence with reasonable caution. For example, in respect to the disputed telephone conversation with Mr. Barton, his evidence was, as to what he probably said, reflecting to my mind the reality that he was unlikely to remember the details, and so on.
So he found that neither of the two participants in the all-important telephone conversation could really remember what had been said.
Well, at the end of the day, my lord, I think that is right. That is what he found. Although, insofar as he was relying on anyone's evidence, it was Mr. Rook's, and we'll see that again in a moment. It wasn't Mr. Barton's. Then paragraph 141 on page 236, this is where he deals with Mr. Morris's evidence that I've shown you in paragraph 116. I found the evidence of Mr. Morris relating to his original discussion. That's the discussion between Mr. Morris and Mr. Rook about payment to Mr. Barton to be unconvincing. And then if the court would look 6 or 7 lines down, there's a sentence beginning in the middle of the line, if, as Mr. Morris asserts, he had been told that it was clear that nothing was payable if the sale price was less than 6.5 million, I would have expected Mr. Morris not simply to consider this to be strange, it would be bizarre to think that Mr. Barton would knowingly have entered into a contract on the terms that Mr. Morris claims were repeated to him, since he would obviously open himself up to a small reduction in the sale price that deprived him of any introduction fee at all. Now, obviously, that passage is something that the Court of Appeal focused on.
I had difficulty in relation to that passage because I'd have thought there would have been an obvious implied term that the vendor could not deliberately manipulate or dishonestly manipulate or unreasonably manipulate the sale price in order to exclude a payment to Mr. Barton. So I just don't follow the reasoning that it's bizarre.
Well, I'm glad your lordship says that. I was going to come on in when I deal with the implied terms to say what I was going to suggest was good faith, but I think similar sort of idea.
Good faith, honestly, reasonably.
I was thinking of Lord Legate's cases about good faith, but that probably what one has here is some sort of agreement that if Fox Paste were to deliberately manipulate the price, that would be a breach of an
or unreasonably
of good faith.
Or unreasonably do so.
Well, maybe unreasonably, yes. Yes. Probably doesn't matter. But that's the way in which that would be dealt with. But in my submission, what the judge was dealing with in this passage, and one needs to remember this is in the section of his judgment dealing with the evidence and whether he's accepting the evidence of the different witnesses and so on. What he's dealing with is Mr. Barton's subjective state of mind. And in the context of a finding about whether Mr. Rook had a conversation with Mr. Morris along the lines that he says he had. Mr. Morris said he had.
Subjective state of mind is is relevant in this situation in a way it wouldn't be in the case of a written contract, though, isn't it?
Well,
on the basis that what the parties, it's the Carmichael case I'm thinking of.
Yes, my lord. Yes, and as I said at the beginning,
goes to what it's likely the parties did agree.
It could do, yes, and I entirely accept that. But what this was not, in my submission, was a finding that, or a conclusion that when the parties agreed what the judge found they agreed, that was bizarre. That was an uncommercial agreement. That's not what the judge was dealing with here, and we'll see what he says later about the agreement. This was just focusing on Mr. Barton, and as I understand it, in my submission, what he was saying was if Mr. Rook had said to Mr. Barton, well, look, you do accept, don't you, that if the property sells for less than 6.5 million, you're going to get nothing. Mr. Barton would have said, oh, hang on, no, I'm not agreeing to that at all. I hadn't thought about that. Let's discuss it. But that, in my submission, is what's going on in that passage. He's not making a finding about, or query whether it's a finding or a conclusion about whether the agreement objectively that was reached by the two parties was bizarre. He's just rejecting evidence of Mr. Morris.
But this is recording a discussion between Mr. Rook and Mr. Morris, who are both on your side of the...
That's right.
As to what Mr. Rook had agreed or discussed with Mr. Barton.
That's right.
So what the judge is saying is that if Mr. Rook had said to Mr. Morris, I discussed this with Mr. Barton and he's agreed he'll get 1.2 million if the property sells for 6.5 million and he'll get nothing if we buy it for less, that Mr. Morris would have said to Mr. Rook, I can't believe he would have agreed that. That's bizarre. So that's what he's dealing with here. But then he goes on to find that is what they agreed.
Yes, objectively.
Yes.
But this is a finding about what was, or rather what wasn't said. That's all in my submission. So he's saying if Mr. At the end of the day,
point that Mr. Barton unknowingly entered into a contract.
that is what he finds, yes. Yes. He says he didn't think about what was going to happen if it was less than 6.5 million. So
That seems to me the kind of...
Well, that is evidence on which the judge was entitled to find that the agreement made by the parties didn't address that situation.
Exactly. But it's in my submission, it's not. The Court of Appeal latched onto that and said, well, the judge made a finding, reached a conclusion that this agreement was commercially bizarre. And I say that's not what he found. That's not what this passage does. And we'll see in a moment where he does deal with the objective approach to the agreement.
Well, he's certainly expressing a conclusion that an agreement which contained an express term to that effect would be bizarre.
Well, he's expressing a conclusion that yes, that Mr. Barton wouldn't have agreed to it if it had contained an express term. Yes.
So...
but that... Sorry.
You can have a...
Sorry.
Yes, I'm sorry.
So he found that there was no agreement as to what would happen as to if it sold for less than 6.5 million, because it wasn't contemplated.
Well...
But what he didn't find is what, if an officious bystander had said, look, Mr. Rook and Mr. Barton, what will happen if Western buy it for 6 million? He doesn't make any finding about whether they would have had the same answer if they had addressed their minds to it.
Lady, I'm going to say both of those things are wrong, with respect. But for reasons I'm going to come on to in the judgment, he does find that the agreement was objectively construed, that if the price was less than 6.5 million, Mr. Barton gets nothing.
Okay.
And he does make some findings relevant to the officious bystander as well, which I'll show you in due course. But in my submission, those points don't quite work. If one stops here in the judgment, one can see that there's a problem. One has to read the rest of it in my submission. So paragraph 152 on page 238 is where the judge deals with the contract claim and discusses the arguments. And then one gets, and in my submission, these paragraphs are critical. Paragraph 153, 154. So in 153, he sets out Mr. Barton's version of the discussion, in which case the court would have clear evidence of an agreement between him and Mr. Rook, and then missing out the brackets, pursuant to which Foxbase were liable to pay the sum of 1.2 million if the purchaser completed, in other words, with no minimum price. Then on Mr. Rook's version of events, it seems to me there's equally clear evidence of an agreement that Foxbase would pay Mr. Barton the sum of 1.2 million only in the event that he introduced a purchaser who completed a purchase on Nash House for 6.5 million. Subject to the contention that there was no intention to create legal relations. Then 154, he says it comes down to a simple question of fact. I accept that either version of events is possible and neither would be illogical. So just pausing there, in my submission, that is his conclusion in terms of the objective approach to the agreement, the objective construction of the agreement. He says neither would be illogical. He's not saying it would be bizarre. And then he says the respondent's argument that the appellant's version, say Foxbase argument that Mr. Barton's version is improbable because Foxbase would be paying a flat percentage regardless of the purchase price, can't be dismissed out of hand as being commercially ridiculous because there is evidence that Nash House was proving difficult to sell and Foxpace saw some urgency in completing the sale. On the other hand, the appellant's criticism of the respondent's argument on the basis it would make no sense for the appellant to enter into the agreement in which he only obtained any fee if the price exceeded 6.5 million, at which point the whole fee became payable, supposes Mr. Barton fully thought through the implications of what he was discussing. So that's the point where he goes on to say Mr. Barton didn't think about this point. But importantly, that word any at the bottom line of page 238 shows that the judge was thinking in terms of the way the alternative case that I showed you in, I think it's paragraph 16C at the beginning, was put, was that if Mr. Rook's version was accepted, then there wouldn't be any fee payable if the price was less than 6.5 million. That's what he understood the argument to be, and that's what he was addressing. And then at paragraph 156, subparagraph D, on page 239, in the last sentence, he says, given the points made at A and B above, it's more likely than not his version of events, sorry, that's Mr. Rook's version of events, is correct. So he's, in effect, accepted Mr. Rook's oral evidence and accepted that on the basis of that evidence, that means that if the price is less than 6.5 million, Mr. Barton gets nothing.
But that is inconsistent with his previous approach, because if it had been said that you'll get nothing, words to the effect that you'll get nothing, if it's not 6.5 million, then that runs into his finding that
The bizarre.
the bizarre.
Yes.
So it must surely have been a situation in which it was just silent about what would happen in that event. What was said was silent about it, not that it precluded anything or decided anything in that situation.
Well, my lord, a combination, really. The judge was saying nothing was expressly said, but that the effect of what was agreed was that you'd get nothing if the price was less than 6.5 million. That is his finding of fact, and I say that then feeds into what he found at paragraph 161, which is obviously the crucial paragraph with the finding in it. But that is what he was finding, ultimately, that the nature of the agreement, which is the case that was being put in paragraph 16C, the nature of the agreement was, if less than 6.5 million, you get nothing. Wasn't expressly said, no one ever talked about it, but objectively, that's what they were agreeing. That's his finding in my submission. And one sees that, as I said, at paragraph 161, which I say is ultimately the key finding that he makes. So he says, for these reasons, I'm satisfied, following discussions between Mr. Barton and Mr. Rook during that period, the appellant and respondent entered into a contract, pursuant to which Foxpace was liable to pay Mr. Barton the sum of 1.2 million in the event that Ash House was sold to a purchaser introduced by Mr. Barton for the sum of 6.5 million. And one has to read the last sentence. Since the property was sold for 6 million, the claim based on the contract fails.
I mean, one's initial reaction is that he's gone from a quite careful and precise fact-finding exercise to determine what was said, and then jumped straight to a conclusion as to what the effect of what was said had as a matter of contract, without considering, for example, implied term. He just says, well, that's what was said, ergo, you get nothing.
Because there's no agreement to pay you anything.
Well, Lord, yes, up to a point, I agree with that. But of course, the reason he doesn't consider the implied term, which he recites in paragraph 164 on the same page, is that the learned friend had made absolutely clear he wasn't relying on an implied term.
Yeah.
And so, and that's why I say my learned friend has a difficulty now if he wants to come to this court and say, I can rely on an implied term. Because for exactly the reason my Lord Briggs has just expressed, that may have been something that the judge would have wanted to consider and would have made findings about. And it's clear from paragraph 164 the judge wasn't minded insofar as he thought about it to agree that there could be an implied term.
Someone discussed Marks and Spencer's and the empty carrying bar, or did he come up with that?
Well, my lady, obviously I wasn't there. I understand that my own friend Mr. Sterling had made it clear, or had asked the judge to establish whether or not an implied term was being claimed by Mr. Pomfret, and the judge then put to Mr. Pomfret, are you saying that there's an implied term on the basis of Marks and Spencer? And Mr. Pomfret said no. I may be wrong about what happened, but that's my understanding of the way it went. So there was a clear discussion between Mr. Pomfret and the judge about whether there was an implied term being claimed, and it was said no, there wasn't. And
so can I just be clear on your submission? What is the contract as found by the judge?
So paragraph 161 is my key finding, and I say what the judge was finding there was if price less than 6.5 million, Mr. Barton doesn't get any remuneration. If 6.5 million or more, he doesn't actually consider more. He says, well, there might have been an implied term, but it must be right. If it's 6.5 million or more, then he gets 1.2 million. I say that is what he actually found. If one...
You say that's what he found. They did agree, even though he found it bizarre that one of the parties would have agreed that.
Yes, because it wasn't expressed. But one knows that things can be implied in a...
But if it had been it could be communicated without being said in so many words, but you say he found it was communicated, which does seem inconsistent. The alternative explanation is he found that they just simply didn't address that situation, and all that was agreed was that in the event that it sold for 6.5 million, you get the 1.2, and nothing else was expressly agreed. But he then goes on to conclude, since there was no express agreement on anything being paid in another situation and no implied term, case fails. Hence the last sentence of 161.
Yes. Well, my Lord, I see the point. But, I mean, in my submission, one way or another, he's accepted the alternative case the way it was put, that the agreement, such as it was, only covered 6.5 million or above, and therefore, if the price was less, then Mr. Barton gets nothing. That is his finding, and it's in my submission a little unfair to say to the...
Well, I can't see that you can say that it's his finding. It's your interpretation of what he's finding. I think you've already conceded, in effect, in answer to Lord Leggett, that there is another possible interpretation, which is that the contract just stops. It doesn't say anything about what happens in relation to a sale at less than that price.
Well...
Or, for that matter, more than that price.
Well, he does deal with the more than that price.
Look at 162 and 163.
Yeah, no, my Lord, of course he does deal with that. And interestingly, when he deals with that, he says, well, there might have been an implied term, but on the facts it doesn't matter, so...
But can I just come back to a point I just wanted...
I'm awfully sorry to interrupt. I'm told that the internet broadcast has for some reason crashed. Is it suggested to be adjourned briefly?
Yes, adjourned briefly.
The engineers are trying to re-establish it. We do place, obviously, a great premium on live broadcast recordings for transparency and open justice reasons. So I'm afraid, with profuse apologies, we'll briefly have to adjourn, and we'll I suggest you remain in court. These things are usually sorted out quite quickly, and we'll come back in when it's been sorted. Yes, Mr. Trujillo, we're back up and running.
Thank you, my lord.
Can I just ask the question I was about to ask?
Of course.
I just wanted clarification as to what you regard, or your submission is, as regards the contract we're dealing with. Is it a unilateral contract, first of all?
Not quite, I think. I have thought about this point, my lord. It's not in the sense that if you have a Carlyle and Carbolic Smokeball type situation, there's an offer out there which somebody can go out and just accept by conduct or whatever. It's not quite that kind of agreement.
Well, it's not an offer to the whole world, no.
And there is an agreement between the parties, so it's not a kind of offer that anyone can come along and accept. There was a discussion between Mr. Barton and Mr. Rook on behalf of the parties, and they reached an agreement. But I do accept that on the terms of the contract, Mr. Barton wasn't obliged to go out and find a purchaser.
Right. So Mr. Barton has no obligations whatsoever. Is that correct?
That's probably correct.
Right. So
he has a purchaser, doesn't he, already?
That was what I was going to come on to say. Exactly.
I mean, one interpretation could be that he agreed to give the name of the purchaser in return for the promise that he would get a commission in the event that the price was 6.5 million.
Thank you, Lord. You've saved me. But yes, that's what I was going to say. I mean, the reality was in this situation that by the time of this agreement, Mr. Barton already had his purchaser. So there wasn't really a risk that he wasn't going to provide the name.
Is he in breach of contract if he did nothing? If he didn't provide the name of the purchaser?
No.
Right, so it's a unilateral contract where there are no obligations at all on Mr. Barton.
I think I accept that, Lord, yes.
Thank you.
And
is that why, because another question that flows from it, what's the implications by law? The Supply of Goods and Services Act 1982 tells us that in normal circumstances where contracts in relation to services do not have a specified price, there is an implied term by law. Why might you, or are you saying that there's no, what is your reason for saying that that isn't applicable?
Yeah, my lord, and I accept I've got to deal with that, and I was just going to come on to implied terms, because I do have quite a bit to say about implied terms. I'm not trying to dodge your lordship's question. Can I just, before I do move on to implied terms, just come back to your ladyship's question about Marks and Spencer and who raised it. Just in the few minutes break we had, I asked Mr. Sterling and Mr. Pumfret about that. The answer is they can't quite remember who raised Marks and Spencer first. It might have been the judge who came up with that. There certainly was a discussion about whether an implied term was being run, and Mr. Pumfret said he wasn't running. So I'm going to come on to implied terms, if I may. Now, I accept I've got to address Lord Barrow's point. That in relation to implied terms, it's clear in my submission from Devaney and Wells, that if it wasn't obvious anyway, that the correct approach to the implication of terms into an oral commission agreement is the Marks and Spencer approach. In other words, one's looking at whether it was necessary, whether it was so obvious as to go without saying, or necessary for business efficacy. I say, if you apply that approach to the agreement found by the judge...
Just before we go there, do you say this is a question of law at this stage? But the judge has found what was said, I think, although he doesn't quite say that in terms. I think it's clearly he has found that what was said was, if this property sells for more than... sells for 6.5 million, you get 1.2. And he's more or less saying, particularly because of his bizarre comment, that's all that was said.
Yes.
Not the add-on bit that Mr. Morris testified that Mr. Rook told him about.
I would say he's not made findings about specific words being said, but he has said what the substance of the discussion was.
Yeah, he's made a factual finding as to what was said, albeit not necessarily word for word. Now, my question is, if we move on to implied terms, are we now getting into an issue of law?
Not entirely. In my submission, where you've got an oral agreement, the question of implication also involves, at least to some extent, findings of fact. Because one can think of circumstances where the implication is all in the tone of voice or the conduct, whether you're shrugging when you say it or whatever it may be. So you in relation to what's implicit in an oral agreement, particularly one as short as this,
but that's the question of what was implicit in the words used, as opposed to when we reach a stage of implying a term under what's now treated pursuant to Marks and Spencer as a separate principle of implication.
Well, my lord, in my submission, you can't actually separate those two things out quite as clearly as your lordship has said. But in effect, the two blur into one another in my submission. You're looking at the implication. I don't want to get drawn into an argument about whether Lord Hoffman was right when he was saying implication of terms were all part of construing the agreement. But in this kind of situation where you've got an oral agreement, one gets much closer to that. I say you can't really consider the implication of the term without divorced from the factual situation.
Well, context may be important, whether it's written or oral.
Well, indeed, that's right.
Indeed, context, once you start getting towards implied terms, may become crucial.
Could indeed. But certainly in this situation where you've got an oral agreement, I say it's not entirely an issue of law. And in particular, for a reason I'm going to come on to in a moment, here it wasn't an issue purely of law. There were factual findings. So I'll leave that point there if I may, unless your lordships want me to deal with it any further. But can I just, as a quickest way of dealing with this, refer to my written case at page 131. I've set out there, paragraphs 65, 66, 67, 68, why I say you can't imply a term in this case that if the price of 6.5 million was not achieved, then you still have an obligation to pay Mr. Barton anything. Paragraph 65, I said it's not so obvious as to go without saying, because Mr. Barton, and this is a key point one always has to remember in this case, the 1.2 million wasn't really a commission in any normal sense of the word. It wasn't a percentage of the sale price. It was obviously Mr. Barton recouping his losses, if I can call them that, in relation to the previous abortive contracts, the deposits that he forfeited. And so he's getting, even on the judge's findings, if one accepts that the market value of the service he provided was £435,000, he's getting 3 times the market value. And so in that situation, it's not obvious that it was intended that he would be paid anything if the price was less than 6.5 million. He was prepared to take that risk. He was obviously a risk taker because he'd entered into 2 contracts previously without having finance.
Was that something known to both sides?
Sorry, was what known to both sides?
That he had lost his deposit twice?
Yes.
So that's part of their common understanding of the history?
Everybody knew that, yes.
And was it also part of their common understanding that the 1.2 million was linked to the amount of those lost deposits?
Yes, my Lord.
Right.
As I understand it, that's what the judge found. Because the contracts obviously were with Foxpace. So we knew, as it were, that he'd lost the money. And that's what he was asking for, and that was all part of the discussion. So he was a risk taker, as I say, and the reality was that he'd already found Mr. Lipson as the potential purchaser. Mr. Lipson was, if I can put it this way, a Barton supporter. And the judge finds that Mr. Lipson came to give evidence, and the judge didn't believe Mr. Lipson because he just said what he thought would help Mr. Barton's case. I know that's at a later stage of the trial, but in the circumstances, one could see that Mr. Barton probably didn't think he was taking much of a risk at all. He'd got a purchaser. He thought the price was going to be 6.5 million, had no reason to think it was going to go lower than that. The person he'd introduced was somebody that was broadly favourable to him. He stood to get his 1.2 million back if he got this, so he was happy to agree that. It's not, in my submission, so obvious as to go without saying that he must have thought he was going to be paid if it wasn't 6.5 million.
So no, the parties have not addressed the question of the reasonable market value of the introduction of Western, because that was not suggested to be the basis on which they were arriving at the 1.2 million. Is that?
That's right, I think, milady. The judge arrived at his valuation of 435 million, and you may remember at the end of his judgment, he says, well, ideally I'd have liked some expert evidence about this, but I'm not going to send the parties away to do that. I've got a couple of other reference points, and I'll just stick a pin in and come up with that value, which of course he was entitled to do. But there was no real evidence about what this kind of service would be worth in the market. And the other thing to remember is a key point in my submissions, I'll say it now in case I forget to say it later, but Mr. Barton wasn't an estate agent. He wasn't an introduction agent. He was a property dealer, in effect. He'd entered into 2 deals before to buy Nash House himself. And was looking.
Yeah, but he wasn't coming along as a friend to give him a helpful bit of, helpful introduction. He was looking for something from him, and so there must have been an understanding that he was going to get paid. I mean, that's the starting point.
Well, there was an express agreement, I would say.
There was, yes, exactly. So the real question is, what was that agreement?
Well, yes, my Lord, although what I said is relevant to the question of whether one would automatically imply a term, because if Mr. Barton is holding himself out as an estate agent with a market rate, with a scale of fees and so on, and that's his job, then everybody knows that when you go to him, that's what he's going to charge. But that wasn't this kind of case. He was just a businessman doing a deal.
And there's no doubt that he had forfeited those
The
deposits, and there was no legal or moral claim that he had to recover them.
I don't think anyone ever argued that he did have a right to recover them, no.
So are you saying that this isn't a situation where we can imply a term by law because it's a typical relationship scenario like Liverpool City Council and Irwin, for example?
Well, I'm certainly saying, I'd consider it by reference to Devani and Wells, and I'm certainly saying it's not like that, because in Devani and Wells you had an estate agent who was holding himself out as charging a fee.
That's window cleaner, isn't it?
Yes, up to a point, lady, yes.
It's a rather arid discussion, isn't it? He was an expert. Mr. Barton was an expert in this area. He had contacts, and he was making his contact available.
I'm not sure I would agree that he was an expert, my lord, but he had contacts.
Yeah,
yes.
Well, he practiced in this area, he carried on business in this area.
Yeah. Yeah, my Lord.
The distinction between an estate agent and a property developer doesn't
it's part of the background against which one considers whether a term can be implied in my submission. I'm not saying, it's not my case, that if there'd been no express agreement at all, there would have been no implied term. There might well have been. It's a hypothetical situation we don't have to consider, but there might well have been. But the point was there was an express agreement here. And it's not so obvious in my submission that if the sale price was less than 6.5 million, he intended to be paid. Can I come on to the second point? Because in a way, the second point is, I say, the conclusive one. And that's the point in paragraph 66. And it relates to the quotation at the top of page 131 in my written case, which is the well-known Philips Electronique, Lord Bingham's words. The question of whether a term should be implied, and if so what, almost inevitably arises after a crisis has been reached in the performance of the contract. So the court comes to the task of implication with the benefit of the hindsight. It's tempting for the court then to fashion a term which will reflect the merits of the situation as they then appear. Tempting but wrong. It's not enough to show that had the parties foreseen the eventuality, which in fact occurred, they would have wished to make provision for it, unless it can also be shown either that there was only one contractual solution or that one of several possible solutions would, without doubt, have been preferred. Now,
that's spoken outside the context, isn't it, of a case where it might be said this is a contract of a type where the law ordinarily implies a term.
You're addressing the terms implied in fact at the moment, aren't you?
Yes.
Reasonable bystander test.
Yes, Your Lordship.
And you're going to come on, I'm assuming, to the argument that puts forward that there's a term implied by law here.
Well, yes, but the two are, in my submission, related, of course. And the point here is that the judge in paragraph 197 on page 248 of the bundle, I'm going to come back to my case in a moment, but if the court would please just turn up paragraph 198, page 248. Now here the judge he isn't addressing an implied term, of course, because one wasn't run, he's addressing the unjust enrichment argument. But he says the court cannot make any safe assumption as to what the respondent would have agreed to if the possibility of a reduced sale price had been contemplated at the time of negotiating the contract. Foxpace might still have been willing to pay 1.2 million to Mr. Barton on the ground that this would have furthered a relationship, might have agreed to a reduction of the 1.2 million, perhaps pro rata, or even by the sum of 500,000 to cushion it from the effect of the reduced sale price. 500,000, of course, is the amount by which the sale price was less than the 6.5 million. It was 6 million rather than 6.5. It might only have been willing to offer 7.25% as a reasonable value of the service proffered, might even have been unwilling to offer any sum, although I accept it's unlikely. It certainly seemed from the email and that's the email referred to in paragraph.
That seems a bit unrealistic, doesn't it? Because if he's prepared to sell the property in effect for 5.3 or whatever the difference is, 6.5 less 1.2, the suggestion that he wouldn't be prepared to sell it for 6 million, if it is absurd, isn't it?
No, my lord, because the point about it is he's had the 1.2. I mean, I puzzled over this myself, my lord, but one has to remember that the 1.2 million is the amount of the deposits that have been forfeited. So Foxpace has got that money, and and of course it was entitled to it contractually, but it's sort of a windfall. It's money for nothing.
For the property, what they get actually at the end of the day, once they transfer the property away, they have garnered from it the 1.2 million in the forfeited deposits, and then the 5.3 million that they would get from the purchase price. If the purchase price was 6.5 million, they had to pay Mr. Barton 1.2 million.
I think that's right, my lady. I've confused myself thinking about it. But the point is that the 1.2 is, as it were, neutral because Foxpace has already had that. So it's not knocking the 1.2 off the sale price in a sense. And one can see that that's how the thinking must have gone. I've had 1.2 million that I wasn't expecting to get. Of course, I'm entitled to hang on to it, and that's lovely. But if I can sell the property for 6.5, and remember the original contract, the Stonebridge contract, as I think it was called, that was entered into, was I think for 6.3 million. So the thinking probably was, well, if I have to give the deposit back, I'm actually not worse off. I'm slightly better off at 6.5 million. But if the price goes down, then I'm not better off. If the price goes down below 6.3, I'm going to be worse off. So that's why it's not at all obvious what we on our side would have agreed. But whatever the position may be, in terms of whether this court would have reached the same conclusion as the judge, that is the conclusion that he reached. Those are his findings about what the parties would or wouldn't have agreed. He says, you simply can't say. And so I say that Malone and Friends stuck with those findings, and he can't have an implied term because there is no obvious contractual solution, and he can't really complain about that because he didn't argue the implied term. As I said at the beginning, I'm not saying he can't argue it now, but he is stuck with what the judge found because he didn't run the point. And really, I say that's the beginning and end of the implied term point.
Well, what about the term implied by law, though, because you haven't yet addressed that? Isn't there a basic norm of commerce that if you make a valuable introduction, which results in a sale of property, you get some remuneration for it? And unless that's displaced by what's agreed, that's part of the bargain.
Well, that's Malone and Friends' argument.
Yes, well, that's what I'm waiting for you to hear from you what the answer to it is.
But of course, I mean, if one looks at Section 15 of the Supply of Goods and Services Act, on page 145 in Malone and Friends' written case, it says, where under a relevant contract for the supply of a service, the consideration for the service is not determined by the contract. But I say it is determined by the contract here. The parties had an agreement about the remuneration.
Well, that goes back to the question of whether they've agreed about the remuneration that happens in this situation or not, which is one of the issues.
Well,
but on one view, they haven't. They've not agreed what's to happen in this situation expressly in their contract, so they haven't displaced the basic norm, which is that you get a reasonable remuneration if nothing's been agreed to cover the situation that arises.
Well, in my submission, that's not the way the law works in relation to commission agreements like this, and one sees that from Luxor and Cooper. And perhaps I should go to that.
Can we just before you do?
Yes.
I am just concerned about this section 15 point.
Yeah.
It says we're under a relevant contract for the supply of a service. I think when you go back to what is meant by that in the Act, it says where it's a relevant contract where a party agrees to supply services or words to that effect, which is why I was pressing you on the unilateral contract analysis, because if this is a unilateral contract, it would appear that Section 15 is not applicable, even if the point about that you've just said about the consideration being, on your view, determined in any way in the contract, even if that were wrong, I'm not at the moment convinced that Section 15 can apply, and I'm just wondering if that is also your submission.
Well, I'm grateful for that, and I confess that I haven't thought about that point. And the reason why I didn't think about that point is that it seemed to me that Malone and Friend would probably say that even if Section 15 didn't apply, the common law would say that in these circumstances, if there were no agreement, of course my case is there is an agreement, so that's the end of it, but if there were no agreement, the common law would say there should be a term as to reasonable.
But that common law is dealing with normal circumstances where you've got a bilateral contract. It's not dealing with this, on the face of it, bespoke unilateral contract, which is why I, at the moment, have some hesitation just saying it's all worked out in the common law, because you might say Section 15 is just a statutory
reflection of the
common law.
Yeah. Yeah, well, that's certainly the way that I had seen it, my lord. And I think I'd reasoned it in a slightly different way, which is that even if one's talking about the normal common law position, where you've actually got an agreement, as here, that deals with remuneration, then you're into what I would call Marks and Spencer. You're into implying terms in the normal way. You can't just say, well, because if there wasn't an agreement, there might be a term implied by law, that where there is an agreement, there's still a term implied by law if the agreement doesn't quite go far enough. My submission that just doesn't work. You've got to analyse it by reference to Marks and Spencer.
If your primary case had succeeded at trial and you established there had been, the parties had not actually concluded a binding contract, then I think you would accept that there would be a claim for unjust enrichment as to a reasonable amount, but that Mr. Barton could never have got the 1.2 million, even if the property had ultimately sold for 6.5.
Yes. There would have been potentially an unjust enrichment claim, not an implied term claim, because there wasn't a contract.
Yeah.
But there potentially would be an unjust enrichment claim in those circumstances. But then that is excluded by the fact that there's a contract.
Yes.
That's the last part of the argument.
You wouldn't have got to a situation which is that he would be entitled to 1.2 million if Western buy the property for 6.5 million, and if they buy it for less, then he's entitled to 435,000.
No, that only arises on a contractual analysis.
Yeah.
Because for unjust enrichment, as Benedetti held, you get the market value of the service. Benedetti is a case I remember with a slight wince every time I think of it. But anyway, so yes, your ladyship's right about that. But I think I was going to come to Luxor and Cooper, if I may just try and deal with it briefly. That was a case where Mr. Cooper had reached an oral agreement with Luxor and with Regal Hastings that if Mr. Cooper introduced a purchaser who bought the cinemas owned by the two companies for at least £185,000, the companies would pay Mr. Cooper £5,000 on completion. And he did introduce the splendidly named Colonel Barton, but that sale didn't go ahead because there was a row amongst the directors of the companies, and so the sales didn't proceed. And Mr. Cooper didn't claim entitlement to a commission per se, but he claimed the same amount in damages for breach of an implied term, to the effect that after he'd introduced a ready and willing purchaser, the companies shouldn't exercise their right to refuse to continue with the sale without just excuse or reasonable cause, was the way it's put. And that was based on Court of Appeal authorities. Now, I'm just outlining the facts there. None of that really matters for my purposes. All six of their lordships unanimously, I think it was 6 of them, seems rather odd, but I think there were 6, unanimously agreed that there was no such implied term. The implied term was obviously different, but it's what they say about the nature of the commission agreement. So Viscount Simon on page 626 said he deals with 3 classes of case in the passage that starts in the paragraph about a third of the way down the page. And the third class, I'm going to pass over the other 2 just because they're not relevant and it takes too much time, but the third class is about 8 lines up from the bottom. He says there is a third class of case to which the present instance belongs, whereby the express language of the contract, the agent is promised his commission only upon completion of the transaction which he's endeavouring to bring about between the offeror and its principal. As I've already said, there seems to me to be no room for the suggested implied term. The agent is promised a reward in return for an event. The event has not happened. He runs the risk of disappointment, but if he's not willing to run the risk, he should introduce into the express terms of the contract the clause which protects him. Now, my Lords, obviously, as I said, the implied term there that he's considering is different, but what I get from that is that the burden is on the party in the position of Mr. Barton in these kind of circumstances where you've got an event that triggers payment. The burden's on Mr. Barton to introduce an express clause dealing with what's to happen in different circumstances, not on Foxbase. So if there's silence, it's for Mr. Barton to deal with. Then if I could skip straight to Lord Wright, because I don't want to run out of time. The critical passage in Lord Wright's judgment, and all of Lord Wright's judgment is interesting and helpful. But on page 651, he refers to, about halfway down the page, a case called Howard Holder and Partners and Manx Isles Steamship. And he proves what's said in this case. He says Mr. Justice McCarty had dealt with a case in which a shipbreaker had effected a charter party, which contained an option to the charterer to purchase the ship for £125,000 and entitled the broker to commission on that sum should the option be exercised. The option wasn't exercised, but the market having fallen, ship owners and charterers agreed by a new agreement with which the brokers had nothing to do that the vessel should be sold to the charterers for £65,000. Mr. Justice McCarty held, rightly as I think, that the brokers could not claim their commission on either the £65,000 or on a quantum merit. He said, it is a settled rule for the construction of commission notes and the like documents which refer to the remuneration of an agent, that a plaintiff cannot recover unless he shows that the conditions of the written bargain have been fulfilled. If he proves fulfilment, he recovers. If not, he fails. There appears to be no halfway house, and it matters not that the plaintiff proves expenditure of time, money, and skill. The learned judge quoted a number of cases in support of that proposition, which would apply equally to an oral argument. So, Lord, in a way, the facts of that case are quite similar to this case. You had an agreement under which a broker would get commission if a certain price was achieved. There was nothing in the agreement about what was to happen if it was a lower price. In fact, it was sold for a lower price, and there was no entitlement to commission, because if you want commission in those circumstances, you've got to say so.
But it was sold to somebody else for a lower price. The point is that in these situations, there's no benefit conferred on the seller by the agent.
No, my Lord, I don't think that's right, if I may say so. The option was to the charterer to purchase the ship for 600, and then the vessel should be sold to the charterers for 65. And so I think, as I've understood,
just the agreement with which the brokers had nothing to do.
Yes, so the brokers were left out of the subsequent deal, and then they got nothing.
Right.
But the broker wasn't a sale broker, he was a charter broker, by the look of it.
Well, yes, my lord, but it was still a
What
commission.
he'd done was to set up the charter.
I mean, that's the same as my point that Mr. Barton wasn't an estate agent. There was a commission agreement, and it didn't apply, and that's that. And that, I say, that's the common law position established by the House of Lords in relation to commission agreements. You don't get into implied terms about what normally happens in the market, where you've got an express agreement.
Is that case Howard Holder in our bundles?
I'm afraid it isn't, my lady, and it probably should have been, and I apologise for that, because I don't think I'd realised quite how important it was until I read the bundles.
Well, we could find it.
But I rely at any rate on Lord Wright's approval of those words at the end of that paragraph. So he's plainly approving that as the analysis. Now, I'm slightly worried about the time, because I realise I've not got to unjust enrichment yet. But I should deal, and it's relevant to the unjust enrichment point as well, I should deal in this context with Firth and High Lane, because Firth and High Lane really, in my submission, is about an implied term. It's not really about unjust enrichment. And I accept it has one or two dicta in it that are potentially helpful to my learned friend. But ultimately, I say some of those dicta are a bit doubtful. Ultimately, it was rightly decided, but not necessarily for all the reasons that their lordships gave. But obviously, the Court of Appeal relied on it, and so it's important to go to it. It's at page 600. It starts at page 600 of the bundle. Which, for some reason... Yes, so it's slightly difficult to pick up the facts from Firth and High Lane. I'm afraid one needs to look at it in a little bit of detail. So starting on page 601, you see at letter A, just above letter A, the paragraph, the property owned by the defendants consisted in the main of garage premises, showrooms and a forecourt. Mr. Firth, who practised under the style of Firth Gibson Partners as an estate agent, so it was an estate agent case, got in touch with Mr. Lane, who at all times was acting as agent for the defendant company, High Lane Limited, in September 1955. Then, if one skips a paragraph down to C, the defendants wanted to sell their property. Mr. Firth wanted to assist them to sell. Quite naturally, Mr. Firth, whose work in life is that as an estate agent, would expect to be remunerated for his services. There was an agreement made at the interview in December following which 2 letters passed between the parties. Just pausing there, again, I draw your lordship's attention to the fact that it was obviously important in the reasoning that Mr. Firth was in the business of being an estate agent. That's a key point. Just reading on, it was...
for the purpose of an expectation that he would be remunerated for his services.
Because that's what estate agents normally do. And there's normally a way of remunerating them by a commission. And then carrying on, it was contemplated at that time that an auction would be held in order to try and sell the property. So Mr. Firth wrote the letter of the 15th of December. And then I don't need to read all of that, but just 2 lines up from the bottom of the page, the letter ended with this passage. I also beg leave to confirm that you're agreeable to disburse all out-of-pocket expenses in this matter, together with the sum of £1,000 commission, to be payable upon our introduction of a ready, willing and able purchaser at a figure acceptable to yourself. And there was then, if one looks on the next line, there was then a letter dated 23rd of December in these terms. This is from Mr. Lane. I confirm our telephone conversation of today's date when the following points were clarified between us. That shows there was a conversation. one that is now material, is D. The penultimate paragraph of your letter of the 15th should read to yourself, on completion of sale of not less than £35,000. So that the provision as recorded in writing was that the company would disperse all out-of-pocket expenses in the matter, together with a sum of £1,000 commission to be payable upon the introduction by Mr. Firth of a ready, willing and able purchaser at a figure acceptable to the company on completion of the sale at not less than £35,000. That was the agreement that they reached. You get £1,000 if the sale price is £35,000. Towards the bottom of that page, opposite letter E, in the middle of the line, sentence beginning, Mr. Dean, who was counsel for Mr. Firth, has told us that in adopting that form of pleading, he had in mind some words used by Lord Watson, where Lord Watson said, when a proprietor with a view of selling his estate goes to an agent and requests him to find a purchaser, naming at the same time the sum which he's willing to accept, that will constitute a general employment, and should the estate be eventually sold to the purchaser introduced by the agent, the latter will be entitled to his commission, although the price paid should be less than the sum named at the time the employment was given. Just pausing there, obviously one can accept that. If I go to an estate agent and I say, I'd like you to sell my house, and I'm looking for a price of £5 million, please, then when the agent finds a purchaser and it sells for £4 million, it doesn't mean that you're not going to get paid. And that's obviously right, but that's a different situation. Then in the next paragraph, the sum of £1,000 mentioned as commission in this case was a very high figure as commission. Well known, there's a scale which is usually followed when estate agents do work and claim fees. Mr. Firth did not necessarily follow or adopt any recognised scale, but it's beyond question that £1,000 was a very high commission. The learned judge was clearly of the opinion that Mr. Lane felt that he would be fortunate indeed if he could get his figure of £35,000 for the property. And if he could get £35,000, he was well content to pay the large commission of £1,000. So what was set out in the letters was that Mr. Firth was making a note of the fact that Mr. Lane had said he would pay £1,000 commission if Mr. Firth introduced somebody who did in fact pay £35,000. That was a special sum. But suppose that the plaintiff, as an estate agent, introduced somebody as a purchaser to the defendants, and the defendants accepted the introduction and did sell to such a purchaser at less than £35,000, then it could not be that the plaintiff was not to be remunerated at all. That would be most unreasonable and couldn't have been in the contemplation of these parties. Now, pausing there, my lords, that's the part of the reasoning that, in my submission, is somewhat suspect. If what had happened was that the property had sold at auction but less than £35,000, in my submission, it's very difficult to see that Mr. Firth would have been entitled to any commission on the basis of the agreement that was reached. One might be able to get there if one can accept the designation of £1,000 as a special sum, if what's meant by that is that the parties had somehow understood it to be either a sort of bonus, but a bonus implies something on top of what you're already getting, or they were accepting that there was going to be a payment in any event, but if you get this super price, then you'll get this amount of money. If that's the way it's construed, then I accept that it works.
Isn't the next sentence, though, the basic principle?
I can't quite remember where I stopped.
Letter E, if you invite somebody.
Yes, and of course that's the bit that my learned friend relies on, and that's the point that your lordships and your ladyship have been putting to me. And that's the bit that I say is wrong. If you reach an agreement that says you'll be paid £1,000 if this sells for £35,000 at auction, you have the auction and the property is sold for £31,000, that's that. You get nothing in my submission, because the parties' agreement determined the remuneration you were going to get. What actually happened in this case was that there was an auction, and I think one sees that if one goes down to page 604 at letter F. These general considerations continue to apply as the later history of the case develops. Later history can be shortly outlined. I'm not sure it was very short, actually, but anyway. It was contemplated as the letters in December show that there would be an auction. An auction was in fact held. The highest offer at the auction was one of $29,500. That was in fact offered on behalf of the Ministry of Works. Mr. Firth had no authority to accept that figure. Mr. Lane was sitting behind him. Mr. Firth referred the offer to Mr. Lane. Mr. Lane said no, in effect. But then what happened, down at sort of between letters C and D, Mr. Firth clearly remained in touch with the Ministry of Works, then represented by Mr. Drake, and many letters passed which could only have been written on the basis that Mr. Firth was still acting in the matter. Now, as I say, that's the basis on which this case actually was rightly decided, because if you agree, I'll pay you £1,000 if you can sell this property for $35,000. You get nothing if it's less. There's an auction and nobody offers anything like £35,000, then you carry on saying, well, please will you just carry on negotiating with the Ministry of Works for me? And later one sees that Mr. Firth was given authority to make an offer. It's on the next page, page 606. He made an offer of £32,000. It's obvious in that situation that the original contract, the original agreement, you only get £1,000 if it's £35,000 or more, has come to an end. The parties are then working on a different basis, because otherwise Mr. Firth would be working for free. He knows it's never going to be £35,000, but he's still working, and Mr. Lane is still asking him to act. And so you see at page 606, letter A, he wrote a letter to Mr. Drake. After a tremendous struggle, I've now succeeded in obtaining authority to offer yourselves the whole of the property and land for the sum of $32,000, and so on. Mr. Lane said that wasn't written with his authority. The judge held otherwise. And then the last sentence of that paragraph, if the argument presented to us on behalf of the defendant is right, then this offer put forward on behalf of the company and with their authority was not put forward by Mr. Firth in his capacity as an estate agent and could not result in any remuneration to him if Mr. Drake accepted and bought at $32,000. That just does not make sense. And I agree. And that is the basis on which this case was rightly decided. Then I'm not going to read it all out to your lordships. It would just take too long. But the negotiations between Mr. Firth and Mr. Drake for the Ministry of Works continue. There's then another agreement that if it's sold at a certain price, £500 will be payable. But that doesn't work out either. Mr. Firth then continues yet further, and at the end of the day, the property is sold, I think, for £31,000, and the judge says, well, he's entitled to £450 remuneration. Now, on those facts, one can see that it was obviously right to say that the original agreement had come to an end and that it should be implied. There was an implied contract, in effect, that if Mr. Firth continued with his negotiations, he didn't even have to introduce anybody because it was the same purchaser. But if he continued with the negotiations and reached a deal, he would be paid. And Lord Justice Sellers, whose judgment starts on page 611, effectively decides it on that basis. He says, at the beginning of his judgment, the defendant's garage in question was sold in December 1956 when over 12 months had gone by since the property had been placed before Mr. Firth, an auctioneer and estate agent, perhaps at his instigation to try and effect a sale. So in other words, he'd gone on acting for a year, well after the auction at which the original £1,000 deal was contemplated. And I think, yes, on page 612, at letter B, he talks about the two deals, the £1,000 and the £500 deal, and says, but how either of those two bargains for a given commission in special circumstances could support the argument that there was no retainer and there were no circumstances in which commission could be recovered unless some precise figure was obtained, I found the greatest difficulty in understanding. So he's saying, well, in effect, you've had somebody acting for a year, and they're obviously on a retainer. And the two deals were the sort of specific deals at particular points in time. But that doesn't mean you're going to get no commission. And I don't think I need to go to Lord Justice Pearce's judgment on page 613, but it's essentially the same point. So I say...
So what was how did they arrive at the quantum that was...
The quantum, I think, was the deal that had been reached, the £500 deal that came up at the end, was on the basis that the property would be sold for, I'm probably going to get the figures wrong, but I think it was £30,000 plus a certain amount for plant and machinery or whatever, something that was in the garages. And what actually happened ultimately is it was, instead of £5,000 for that, the material that was in the garages, it was £1,000, so it was sold for £31,000. And the judge said, well, if you were going to get £500, if it was £35,000, I'm going to reduce that a bit because it was £31,000. And that was the...
So he got a prorated...
Prorated, exactly.
Yeah.
Based on his £500 deal. And one can see that makes sense, because if he was prepared to accept £500 for a deal at 34,000, whatever it was, then he couldn't get more than that if the deal was less. So I don't say that case was wrongly decided, but I do say that a bit of Lord Morris's judgment in particular at the beginning, which ultimately didn't matter because it's about the original auction and things moved on. But his dicta there, where he's saying just on the basis of the £1,000 agreement, still you were going to get paid if the price was less than £35,000, I say that's wrong. And I say that on the basis of Luxor and Cooper and all the other cases that I've been discussing.
It's interesting that he refers to counsel citing from Luxor and Cooper.
Does refer.
He doesn't, at that point, sort of respond to the citation.
No.
Have I missed some other part of the judgment where he does?
No, you haven't. There is only one reference to Luxor, and I'm sorry I've lost it.
Well, it was back at...
604.
Yeah.
Thank you, Lord.
So you get the detailed citation from Luxor. Well, actually, it's all Russell.
Yes.
In Luxor and Cooper, not the two which you cited, but none the worse for that. And then he just carries on.
Yes, I mean, he refers to it on the basis of Lord Russell's comments about there's no peculiar rules, etc. No general rules can be laid down, and so on. And then he says, I think he says at one point, actually I said there was no other reference, I think he may say at some point that there's nothing in the case that leads him to any different conclusion, words to that effect. But yes, he doesn't deal with the detail of that case. It may be that because of the facts of Firth and High Lane, it just wasn't necessary. And as I say,
in that sentence at the end, at 603E, he's dealing with a situation where a specific charge has not been agreed upon.
Yes.
So I didn't read that as referring back to the situation where there has been a specific charge agreed upon, but only subject to a particular condition which is not in the event met. I mean, that final sentence is entirely unobjectionable. It's only, you say, becomes objectionable if you superimpose it on a situation where there has been a special sum agreed triggered by a particular event and the event doesn't happen.
Yes. And it could depend on the precise words that are agreed. Of course I accept that. But if what's agreed is along these lines, that's that.
I'm also on Lord Russell. He takes the line, doesn't he, that an ordinary estate agent contract is actually a unilateral contract. It doesn't oblige the estate agent to do anything. But if he does, then, and the condition for the payment in the contract is satisfied, then he gets paid.
Yes, that's right. He does say that.
Yes, and one assumes that estate agents' ordinary scale of fees are set at a rate that enables them to recoup from the sales that they do make the cost of all the time and effort they put in with other houses that they don't actually manage to sell.
Dare I say it, it's like lawyers who have conditional fee agreements. One assumes that you will win on enough of them and make enough of an uplift that you'll recoup losses for the ones that you don't win on. And I mean, that was a point I think I skipped over it in the course of discussions, but I was going to make. My learned friend says that my approach is all very uncommercial, that you should have an agreement that means you don't get paid if you don't achieve a particular success. But of course, that's the case with any kind of no-win, no-fee, success fee type arrangement. If you don't hit the target, you get nothing. Or you might get a lesser rate or whatever it may be, but that's the nature of the deal. And I should also deal in this context with, I think we touched on it actually earlier, but my learned friend's point that we could have somehow come to an agreement that was for £1 less than 6.5, thereby avoided the price. I mean, there's obviously the point that we touched on earlier, that there might be an obligation of good faith or whatever in that situation. But I say anyway, it's inherent in all kinds of success fee type case. And it happens with lawyers too, that you get success fees that are calculated by reference to the particular award of damages, and if you get a bit less than that, well, bad luck, you've done lots of work and you're not going to be paid for it. But that's not, one can't say that's uncommercial. There are all sorts of reasons why parties do deals of that kind. And that comes back to the sort of Marks and Spencer approach to the implied terms. I don't think I got on to the point about necessary for business efficacy, but that's why I say implying a term here isn't necessary for business efficacy, because people all the time do deals on the basis of no win, no fee, success fee, or whatever it may be. It's a perfectly sensible commercial proposition. It all depends on the situation, and here Mr. Barton was prepared to take a risk because he thought it was probably a safe bet. So I see my Lord Spriggs looking at the time, and I know
Unjust enrichment.
Yes, I better move on to unjust enrichment. And the unfortunate thing about unjust enrichment is there's so much written about it that obviously I'm not going to be able to show your lordships very much of it at all. But I'm conscious that Lord Barrows, at any rate, has written quite a lot of it, and therefore probably doesn't need me to show it to him. But what I say is that if there is no express or implied term entitling Mr. Barton to payment in the circumstances that have happened, and if there is an express or implied term, then we don't need unjust enrichment because he's going to get paid anyway. But if there isn't one, then it's wrong to say that he can get home in a claim in unjust enrichment. And can I start my explanation with an example that's different from the facts of this case? but hopefully simple. If one imagines that I'm a painter by trade, and Mr. Pumfret calls me up and says, could I paint the windows of his house? And we agree that he'll pay me £500 for the job. And I go and do the job, and I finish the job, and I do a perfect job. There's nothing wrong with it. No one can say I haven't completed the task. So unlikely that that would be the case with my painting, but leave that to one side. And then he refuses to pay me the £500. Can I say that although I have a claim against him in debt, it's not a breach of contract, it's a debt claim because he promised to pay £500, he hasn't paid it. Although I have that claim, I also have a claim in unjust enrichment. And £500 was way below the market rate for this kind of service. On the market rate, I could have charged him £5,000. So I'm going to claim in unjust enrichment. He's been benefited at my expense, and I'm going to get £5,000. Now, instinctively, I would suggest, and maybe that the court feels differently, but instinctively one would say, well, no, that just can't be right. And I say it isn't right. And the question is why? Now, one reason that could be given, and is given in some of the writings on the subject, is that the express agreement implicitly excludes unjust enrichment. And I think my learned friend would put it in that way, looking at his case. But the problem with that in my submission is it starts from the assumption that an unjust enrichment claim is otherwise available. And the only reason you can't have it is because there's something implicit in the contract that excludes it. I say it goes deeper than that. You can't have an unjust enrichment claim as a matter of law and not just as a matter of agreement. And there are two reasons for that in my submission. The first is that where services are provided pursuant to a valid and enforceable contract, then the contract provides a reason, a basis for the transfer of the benefit. And that negatives any possible unjust factor. So no claim in unjust enrichment can arise. Now, my lords, I was going to go to some passages from Mann and Patterson. I'm reluctant to do that because I'm going to run out of time if I do. But perhaps if I can just, for your lordships and your ladyship's note, say that in the judgment of the minority at page 1318, paragraph 14, there's a useful summary of all the relevant law in relation to what one might call the lawful basis bar. That's, I think, Professor Virgo's wording, or one might call the subsisting contract rule. And the logic, and it's the Costello, it's what Lord Justice Etherton said in Costello. The only reason for not going to Costello is that I quite see that on the facts one can distinguish it. It's about the three-party case and so on. And that's what my learned friend says. Well, Costello's got nothing to do with it. But it's the principle that's in Costello, which is the parties have agreed the terms on which the benefit is being transferred. Contractual certainty and party autonomy means that unjust enrichment should not interfere with that contractual allocation of risk, if one wants to call it that. So in my silly example where I'm the painter, we agreed the price of £500. It would undermine that agreement if I were able to elect to make a claim in unjust enrichment and recover more than that. That's the first point. The second reason why I say no unjust enrichment claim lies is a bit narrower and a bit more technical. It's that where services are provided pursuant to a request, the unjust factor that gives rise to the potential unjust enrichment claim is a failure of basis. Failure of basis simply means that when you look at the transaction objectively, the services were provided subject to a condition. The condition being, in this case, that payment would be made, and the condition has failed. And although I can't get my services back, as it were, I'm entitled to restitution, so a reasonable market value for those services. Now, in my example of painting the windows for £500, although in one sense, in a sort of simplistic sense, one can see that the basis has failed because I haven't been paid, nevertheless, I've earned the contractual right to payment. I've got a contractual debt, and I can enforce it. And on that basis, there's no failure on that assumption, not on basis, one uses basis too many times. On that assumption, there's no failure of basis. I can still get exactly what I bargained for. The court can order payment, and I've got my payment.
What do you say about the failure of basis alleged in this case at page 168, paragraph 94, which is the
well,
that's the last sentence on page 168.
Yes. Well, then your lordship is getting into what I call, for shorthand, Roxburgh. And Roxburgh, I accept, is an exception to the normal position. And what I was going to suggest about Roxburgh, particularly because of the time, is that it might be better to see the way my learned friend puts it, because the Court of Appeal definitely did not decide this case on the basis of Roxburgh and Barnes and that line of cases. That's where you have a non-promissory condition. And that condition is something that's fundamental. It's like a substratum to your agreement. Roxburgh was the point about the tax being valid. Everybody assumed that the tax was valid, and that underlay the whole agreement. I say one just doesn't get into that kind of scenario with these facts, because it's all about payment.
But why doesn't one get into it on these facts? I mean, the example you've given us is a straightforward, valid contractual obligation to pay a certain sum of money.
Yeah.
But it's been put at paragraph 94 that one may see the failure of basis on these facts as the non-promissory basis. That is, it was a promise to pay on the basis that a sale would go through at 1.2 million. When that basis failed, then one's into the law of unjust enrichment. It's not like your... I mean, if we were to take your painter example and were to change it round to, let's say, there's some frustration or something of that kind, then that would get closer, perhaps, to our facts, where you've got some event that hasn't actually occurred.
What I was going to come on to is that, of course, the facts are different. I accept that. I mean, I'm starting from the sort of simplistic point. Yeah. And the difference in our case is that you had an agreement that said not only that I had to finish providing the service in order to get payment, there was also a condition that had to be satisfied, i.e. I had to achieve success. But I say, if one looks at Goff and Jones and the passages that I've cited, where a service is provided subject to a condition like that, or benefit is transferred, it doesn't have to be a service, of course, a benefit is transferred subject to a condition of that kind, there's no failure of basis if the condition isn't satisfied. The basis on which you're providing the service is that I will be paid, but I will only be paid if the service produces a particular result. And so
if you agreed to paint all the windows and you charged an extra high price because you agreed to get it done in 2 days, and then the weather pours down, so you don't, which of course nobody foresees as a possibility, and it takes you 4 days, then the question is, do you get that money or do you get nothing, or do you get a reasonable amount? That's a closer...
Well, at one time I had an example that was rather like that. The trouble with that is that an awful lot's been written about part performers, and whether in a situation where you're only able to complete part of the services before, for some reason, the contract's terminated, brought to an end by frustration or whatever it may be, or terminated for breach, should you have unjust enrichment in those circumstances. And the Mann and Patterson case is one of those cases. And it's interesting, but what they held in simple terms is where you've actually earned your right before the contract's terminated, you've earned your right to payment, then you've just still got your contractual debt claim. But the point about all those sorts of examples is that's really not this case. The services were provided, they were completed. So if there was a right to payment under the contract, it was earned in our case. And the reason why Mr. Barton's not being paid is that he hasn't earned the payment because there was a condition, a contingency, a condition subsequent that also had to be satisfied, which is that a particular result was achieved. And unjust enrichment doesn't happen. I realise I've kind of sidestepped the Roxburgh point, which I think is a different point, as I understand it. And if I could just deal...
It's really the point that the contract, in a sense, has run out. There was a contract, that's true, but if, contrary to your submission, we were to find that that contract did not preclude payments for services rendered, then one has a situation where the contract has run out. And that running out is because there has been no sale at the 1.2 million. That basis, therefore, on which both parties were operating and never thought anything more about it, has failed. Objectively, that was their shared basis. And one then goes into whether a benefit has been rendered that one can value, which of course one can.
The problem with it, and I was going to try and develop it in more detail, but I'm running out of time. The problem with it is that the basis here on which the service was provided contemplated that the sale might not be at 6.5 million. Even if you were to say it didn't deal with what was to happen if it wasn't 6.5 million, it was still an express agreement that said you get paid 1.2 million if the price is 6.5 million. So this is not, as it were, a sort of non-promissory condition, something outside the parties' control that they haven't negotiated about. They had negotiated about exactly that. They'd negotiated and reached an agreement about a condition, as it were, that it was conditional upon 6.5 million being the purchase price, that there would be payment.
And you presumably say that this contract didn't just contemplate there might be no sale, but that there might be a sale at less than 6.5.
Indeed, it did contemplate exactly that, Lord, yes. One can't say it didn't, because it was expressed in terms of if or in the event that there is a sale at 6.5 million. So the parties have really dealt with it. And I say...
So you're really back to Lord Bingham's dictum that they have dealt with it even in their contract, even if they didn't realise they were dealing with it.
Yes, they've sort of imperfectly dealt with it in a way. And then you have to ask, well, if they had negotiated about the point, what agreement would they have reached? And on the judge's findings, who knows? I simply can't say. Now, my Lord, I say it's exactly 12:30.
Well, yes.
And I have rather skipped through unjust enrichment.
Well, we have your written case.
Yes, my Lord.
On the subject, which is nothing if not comprehensive.
Too long, probably.
So I'm afraid we've probably got to...
Probably run out of time, and unless I can help your lordship and your lordship further, I'll say I may have to come back to it in reply.
There is sometimes a regime under which if you're burning to say something, you can have it docked off your reply time, but I'm not encouraged.
Well, no, my lord, and I think I'm happy to deal with anything in reply, assuming it's appropriate to do so.
Very well.
So unless I can help you further.
Well, thank you very much. Mr. Pomfret.
Pleasing, my lord, my lady. I'm going to endeavour to follow through the structure of our written case in my submissions. I wanted to start, though, by taking a step back and looking at the facts. This is a case where Foxpace wanted to sell Nash House. Mr. Barton had a buyer and wanted paying to introduce that buyer. Foxpace and Mr. Barton agreed a price for Mr. Barton to introduce on the basis of the sale price contemplated at that time. Mr. Barton introduced the buyer, who completed the purchase, and then for unexpected reasons the price was less than was contemplated when Mr. Barton and Mr. Foxpace made his agreement. So Mr. Barton hasn't earned his 1.2 million, but can it be right that Mr. Barton receives nothing at all for the valuable introduction of the buyer? And in essence, our case is that that can't be right, and he must be entitled to reasonable remuneration. Looking at the synopsis of the case first, what we say essentially is that this is really what I might call an old-school quantum merit claim. It can't sensibly be disputed, we say, that where a person provides another with services in a context where neither party expects that they're provided gratuitously, the service provider is not usually entitled to receive reasonable remuneration for what's provided. The legal basis for that award may sometimes be contract, it may sometimes be unjust enrichment, and as we say in our written case, historically, the courts have often not troubled too much with the distinction. The key question we say, therefore, on this appeal is whether the parties' express agreement excludes such a claim in the event that it did transpire. Our case is that it didn't, and in a nutshell, it's because the true agreement wasn't that Mr. Barton would be paid if and only if, and we say that for the analytical purposes at least, those words make a difference. We say, therefore, it wasn't an agreement of if and only if. The price was 6.5 million or more, because we say that such an agreement would indeed be bizarre, or at least would not have commercial sense. We deal with the reasons why at paragraph 18 of our written case, which is...
So the obligation, therefore, is on contracting parties to specifically exclude unjust enrichment in their contracts before they achieve that result.
What we would say is that the default position in a case like this, whether it's a matter of contract or unjust enrichment, is that a provider of services would expect to be paid for them, or the law would expect the recipient of those services to pay for them, and if the contract doesn't exclude that possibility, then that would be the conclusion. So in which case, I suppose the onus would be on the party who didn't want that position to apply to include a term to ensure it didn't.
How does that sit with Luxor?
Well, what we say about Luxor's a different case, because Luxor's a case in which the sale didn't complete.
Sorry?
Luxor's a case in which the sale didn't complete. The agent didn't introduce a purchaser who ultimately completed the sale. So we say it's fundamentally different. Mr. Barton would not be able to say that he was entitled to be paid if he hadn't introduced a purchaser who completed a purchase. Luxor's then a case that, as their lordships all say in that case, every contract must be interpreted in its own, on its own terms. It doesn't really have any wider application, we say, than that. To the extent that it does, the Howard Holder case, and I'll look at this when I look at Firth and High Lane, but the Howard Holder case was decided on the Latin maxim, which I can't pronounce, but means to the effect that what's written excludes what would be and what would otherwise be included, or with that effect. Now that the judge in Firth and High Lane does say, well, that doesn't apply in this particular case. And so in my submission, he does say Luxor and Cooper doesn't apply in that particular case. Like, of course, it didn't apply in Devaney and Wells to displace the common understandings that were applied there, that the purchaser, an agent rather, would be paid on completion of a sale. So just going back to paragraph 18 of the written case, which is page 147. And so we've identified there what we say two key reasons why the agreement wouldn't really work, wouldn't make commercial sense. There's also what Lord Justice Mail says at paragraph 57 in the Court of Appeal, which is that a good reason why it wouldn't make commercial sense is that a sale at less than 6.5 million would mean that, and anything more than 5.3 million would mean that Foxpace was better off selling for less than 6.5 million, which just seems uncommercial. The appellant...
Well, that's the result for which you're contending for in this case.
I'm sorry?
You're contending for a result in which they'll be better off.
Yes.
In fact.
Yes, quite.
Well,
they're better off than correct, but we still say subject to them paying us a reasonable sum or the market value of the benefit. So we're looking at two different things. What the express terms were, which we say, well, they'd be bizarre if they produce a result where you actually end up much better off. But then there's a question of, well, what does the law produce in circumstances where the contract doesn't deal with it expressly? And I say there's a distinction there. The appellants place some reliance on the fact that, well, people do sometimes enter into contingent agreements or no-win, no-fee type agreements. Well, that's true, but first of all, it's all a question of interpretation of the terms of the contract in any particular case as to whether that's what's been entered into. But secondly, the context of this case is that Mr. Barton has nothing to gain from doing a loss leader. He's got an opportunity to introduce something valuable, which is a purchase of a property. And once he gives that up, then he's given up what he has within the commercial relationship between the two parties. There's no one's identified anyway, any real incentive for him to agree to a no-win, no-fee type arrangement.
But if the Western name was valuable because it was thought were prepared to pay 6.5 million, there may, I don't know whether we know, whether there were various other people who would have been prepared to pay 6 million. And I think you must accept that if Mr. Barton had introduced Western had said, we're only prepared to pay 6 million, could Foxpace have walked away and then said, right, well, we're not selling it to you because there's lots of people who are prepared to pay 6 million and we'll choose someone else?
Yes, well, they didn't exchange contracts at 6.5 million, so they only exchanged at 6 million.
Yeah.
There was...
But what was valuable about the Western name, that they were the only ones it was thought might be prepared to pay more than 6 million, but in the event they weren't prepared to pay more than 6 million.
Well, the order of events was that the Western were prepared to pay 6.5 million at the time of the introduction agreement. Then they put forward that offer, it was accepted. Then there was a discovery of the HS2 issue during the conveyancing process, and at that point Western were prepared to complete conditionally at 6.5 million and unconditionally at 6 million. There's no evidence, there's no findings that there was any other purchaser prepared to pay 6 million or more at that point in time. Of course, Foxpace could have walked away and said, well, we'll see if somebody else... There had been another buyer interested prior to and possibly even after exchange of contracts with Western, but there was no indication and no findings there was anybody else on the scene subsequent to the HS2 issue being discovered. I say there's a value in the introduction of a potential purchaser. The value isn't limited.
Well, but the question of that value, how valuable that introduction is, must depend on what that purchaser's prepared to pay for the property, doesn't it? There's no value in introducing someone who's only prepared to pay 4 million for the property.
No, but there's a value once the sale completes to that purchaser. You introduce a purchaser. When the purchaser completes, that's the point of time in which the introducer is entitled to be paid.
There's no intrinsic value in introducing a purchaser, but there is in introducing a purchaser with whom you enter into a transaction. Then you've gained from that introduction.
Yes, my lord, and I say that's why introduction agreements or estate agency agreements, the common understanding is that the agent is paid on completion of a sale out of the proceeds of sale, because that's the point at which the value of their introduction crystallises. Could I take Lordships on to look at the case of Firth and High Lane? My learned friend's already looked at it, but I wanted to take you to some other paragraphs there and endeavour not to cover ground that's already been covered. It's page 600 in the electronic bundle. And my learned friend took you to pages 601 and 602 to show what the original agreement was. And it's worth pointing out on page 602, next to letter B, that the letter of engagement, or the qualifying letter of engagement, was that the sale should be at not less than £35,000 in this case. It specifically said the sale shouldn't be less than that price. Then if we go over the page to 603 in Lord Justice Morris's judgment, my learned friend referred you down as far as letter E, I believe.
Sorry, page?
Page 603.
Thank you. Yeah.
My learned friend took you as far as letter E, I believe. I wanted to draw attention to the words just after that that begin, if you invite somebody to render a service, to which I think my Lord Legate referred in intervention. I want to point to that for two reasons. In my submission, this is a case that can be analysed either as a contract case or indeed it can be analysed as what we now understand as an unjust enrichment case. And that language is consistent with unjust enrichment in my submission. He then goes on next to F to refer to the fact that although the contract didn't set out what the amount to be paid if a sale was less than £35,000 should be if there was a sale, it certainly didn't provide there should be no remuneration in the case of the introduction of a purchaser to whom the company decided to sell for less than £35,000. Then he deals with Luxor, and as I say, in my submission, Lord Justice Morris did deal with Luxor because he first of all cites Luxor. He then refers to Mr. Lahr referring to that Latin maxim that I won't attempt to pronounce. And that's what's referred to in Howard Holder. So in my submission, in rejecting that maxim, his lordship's also rejecting that, in essence, what's said in Luxor and Cooper has anything to say in a case, a normal case, one where we're not dealing with the problem that there was in Luxor, which was with an agent who'd introduced a purchaser who hadn't completed. And he says nothing in this document, as it seems to me, could reasonably be taken to involve if less than £35,000 was accepted from somebody introduced by Mr. Firth and the sale affected. Mr. Firth was to go without any remuneration at all. And so I say, well, that's the exact situation you have in this case. If you replace £35,000 for 6.5 million and you replace 1,000 for 1.2 million, you have the same express agreement. And he goes on to say in letter F, these general considerations continue to apply as the later history of the case develops. And then at letters A and B on page 605, similar statements, which I won't read. I wanted to just deal with what's said in the next few paragraphs there, because some reliance was placed upon his lordship's statement at page 606 next to letter C about Mr. Firth could only sensibly have put that forward as an estate agent, the offer referred to there. Well, the actual allegation in this case was that Mr. Firth's instructions had been cancelled after the attempted sale at the auction. And in my submission, what's being dealt with in those paragraphs that follow is addressing that allegation, which was the instruction had been cancelled, and saying, well, hold on, it can't have been cancelled because he continued to do things, and why would he be putting forward offers if he wasn't instructed, because he'd have no interest in doing that. And then over the page to page 607, because the appellants suggest that following the auction, the situation was different, but you can see, my lords, from page 607, next to so first of all, at the top of the page, the new agreement is set out. This is the one where there's an agreement to take £30,000 for the property plus £4,000 or £5,000 for plant and machinery that's in the property, and a deal of £500 for commission is put forward in that eventuality. And what his lordship says next to letter C is exactly the same points arise in regard to this arrangement and this letter as arose in regard to the December arrangement and December letter. And then next to letter D, the same points about nothing in the letter could reasonably exclude the normal position of payments if there was a lower price. And again, next to letter E, some language that in our submission consistent with unjust enrichment as the basis of the award. And you can see on page 608 at the bottom next to letter D that in fact what happens is it's Mr. Lane himself who makes the offer to Mr. Drake to sell the property, and it's now £31,000, so it's less than the £34,000 or £35,000 composite deal referred to at the top of page 607. And yet Mr. Firth is still entitled to be paid. So we say, again, indistinguishable from our case. And then over the page at 6.
He notes there, it is clear on the finding of the learned judge that Mr. Firth was still active in the matter.
Yes.
But on your case, even if Mr. Firth had not done anything after the auction, if it had been still sold, well, no, then he wouldn't have introduced.
In my submission, my lady, it comes down to effective cause and whether or not he's the effective cause, and he introduced the purchaser who bought. If it was the case that things had moved on so sufficiently that he couldn't possibly be said to be the effective cause of the sale, then that would be different. So, and here in specifically in my submission, what his lordship's dealing with is to address the point that actually it's Mr. Lane, he's the company's agent, it's Mr. Lane who's sent the correspondence that concludes the deal. But he's saying, well, but nevertheless, Mr. Firth is still active, he's still involved, so he should still be treated as the agent. That's what that passage is dealing with in my submission. And then there's then similar statements through the judgment, which I won't take you to all of them, but page 11, C to E. Sorry, that's internal page 11, page 610, letters C to E. Then we go on to Lord Justice Sellers at page 611, who interestingly said once it was established, this is at the top of the page, once it was established that Mr. Firth's instructions hadn't been cancelled, firstly, and secondly, that he was the effective cause of the sale, that there was no defence whatever to his action for reasonable remuneration. And he says next to letter D, the circumstances were such that it was an implied contract, which is again, in my submission language, consistent with unjust enrichment, although he then says at page 612, next to between letters C and D, he refers to nothing inconsistent with an implied contract or term to pay a reasonable remuneration. So he could potentially be dealing with it in either case. And then Lord Justice Pearce, who's got a short judgment, he certainly does refer to an implied term on page 613 next to letter C. So what we say, my lords, is that Firth and High Lane was correctly reasoned, it was correctly decided. It can't be distinguished on the narrow lines that my learned friend suggests, and that this case should be decided in the same way, or the decision the Court of Appeal should be upheld. We say that reflects the general law. In cases of this nature, we deal with this at paragraphs 8 to 15 of our written case, where we deal with, first of all, section 15 of the Supplying Goods and Services Act. We say that whilst that doesn't apply directly, it shows what the normal position would be in a case in which there hadn't been any agreement at all about price.
Why do you say it doesn't apply directly? Is that because there's been a specification of some consideration?
That would be, we would accept that that's right, yes. Because there's been a statement of some price, I'm not aware of any cases where you can then say, well, the Act then comes in to apply, but it shows what the general position would be. Because how we say it works in this case is you construe the contract, and once you construe that the contract doesn't exclude remuneration at anything less than a price of 6.5 million, then you're left with a contract that my learned friend describes as silent, and at that point the position should be the same as it would be in a contract that read like that in the first place.
And what about the other point I was making before, that this provision may not apply at all because there's no agreement to supply services?
Well, I have to confess that hadn't occurred to me either, my lord. What I would say in terms of whether, although it's a contract in which strictly there's no obligation on Mr. Barton to introduce a purchaser, because it's if he does, he will be paid. The context is that he had a buyer in mind who he was proposing to introduce, and so it was an agreement negotiated between the parties to deal with a particular introduction. And so, in my submission, in one sense, he has agreed to provide services, albeit that he wouldn't be in breach if he didn't provide those services. Of course, what we say...
I'm not sure I understand that submission.
Well, we say if you look at the situation and how do you interpret agree in section 15, I'm afraid I don't have that provision that defines the provision that your lordship referred to in front of me. But one has to construe what's meant by agree to provide the services. And if there's a unilateral agreement in the context of this agreement, then one might construe that there's nevertheless an agreement to provide services.
Okay, thank you. And the implied, I mean, the way you've dealt with the Firth case is to say, well, this is ultimately, it doesn't really matter whether it's analysed as a contractual implied term or I think you've indicated as unjust enrichment. But we have to surely decide which of those it is, don't we?
Well, of course, there's been lots of cases where the court haven't decided which is the basis of a quantum merit, as it's been put, or a reasonable sum. Yes, there are differences, my lord, as the lordship well knows, of course. The tests and the to be applied and the considerations are different, but ultimately it gets to the same end in a case like this, we say, which is that you have a contract that doesn't expressly provide for remuneration. The general law requires that there should be reasonable remuneration for services provided. You can answer that solution, you can answer that question either by a contractual analysis or by an unjust enrichment analysis, and in some cases it would make a difference.
What is the general law to which you're referring then?
So this is the section 50. So if we look at the written case, paragraphs 8 to 15, they set out the general law to which... page is 145.
Thank you.
But that takes us back to the 1982 Act.
It does, and then we develop onto Way and Latilla, and the general position in Gwyn-Jones. And later in our case, we develop it in relation to introductions in particular. But we say the general position with common law, pursuant to Gwyn-Jones, is that a party who provides services without an express agreement as to the price to be paid for those services is entitled to reasonable remuneration for those services.
Yeah, the trouble is Gwyn-Jones, as you're no doubt aware, has been reinterpreted as clearly a case on unjust enrichment and not contractual. I'm just anxious to get clear where this general law is coming from. I think it's been suggested that if one has a distinction between implied terms of fact, which must be found either on an officious bystander or necessary for business efficacy, there may be some problems with those two analyses. So we may then be turning to a term implied by law. Now, where do you get your terms implied by law, usually in the law? Well, if it's in a statute, all well and good. But as I'm positing, there's some problem with straightforwardly reading 1982 section 15 as giving you that. Then we turn to, well, where else do you go for terms implied by law? Now, one would normally think of something like Liverpool CC and Irwin, a sort of typical contract that carries with it, by reason of that sort of relationship, a standard implication.
Yes.
But I'm not sure whether you're actually making that submission.
Yes, we are making that submission, but I'm sorry if it's unclear, and that perhaps become clearer when I move on to deal with implied terms later. But yes, we say, first, so to take it in stages, we say, well, you've got section 15, which shows you what the position is with services. We say there's a common understanding in relation to contracts for provision of services that they include a provision to pay reasonable remuneration if there's no express provision dealing with remuneration.
And I think by implication you say it applies as much to a unilateral contract, such as an estate agent contract,
yes,
as to an ordinary bilateral contract.
I say there's no reason why it shouldn't, my lord. If the Act technically doesn't apply, then there's no reason why the common understanding shouldn't apply, because why would the market or anybody say, well, this is a unilateral agreement, section 15 doesn't apply, but therefore my expectations when I perform the contract, when I perform the unilateral contract, are different. And the implication comes, and this is why we say the dividing line between a contractual quantum merit and one in unjust enrichment has often been blurred, is that fundamentally you come back to the same justification for a contractual quantum merit as you do for a unjust enrichment one, which is that the law implies in circumstances where parties perform services not gratuitously and accepted on that basis, that the party should be paid for it, and that's why we have a quantum merit. So you could go back and look for further basis, not only at Gwyn-Jones, but at lots of the other cases over the years, like, and some of them are cited in my in our note, like Prickett and Badger, Craven Ellis and Cannons, Lawford and Billick-Rickey, which are all cases where the quantum merit's described as being implied by the law.
There's a basic norm of commerce that if in a commercial setting somebody provides you with a valuable service at your invitation, it's not gratuitous.
That's our submission, yes. And we then point to take it to the next factor. We'll come on to the case of Devaney and Wells, and we then point to what's said in Devaney and Wells about, well, if there is a common understanding as to how particular types of arrangements, particular types of contracts operate, then that can be used to that should be used to construe the contract in the absence of an express term to the contrary, or it could be the basis of an implied term.
But you're not ruling out the possibility that there might be a contract
No, my lady.
of the kind that the judge found, namely that Mr. Barton would be paid the 1.2 million if the introduction led to the sale at 6.5 million, but not if it didn't.
Yes, my lady, I'm going to come on to this when I look at construing the introduction agreement. What I say is one has to read the judgment very carefully. All he deals with is the question of the circumstances in which £1.2 million is payable. He doesn't, in my submission, deal with an alternative that, well, if I found that 1.2 million isn't achieved, where does that leave it contractually?
I think Lady Rose's point, and may be wrong, is that you're accepting that there can be a contract of that kind, a contract which... under which its effect is that it covers the whole ground.
Yes, it can
be. It's a matter of interpretation of the particular agreement.
Exactly, my lord, yes. That is.
But do you accept further that if the contract does cover the whole ground, then that would exclude not only an implied term to the contrary, but also an unjust enrichment claim?
Yes, we say, my lady, that if the correct construction of the agreement is if and only if, and that's why I say it makes a difference for analytical purposes. If and only if you're entitled to be paid at 6.5 million and not otherwise, then we would accept that that means Mr. Barton can't recover. It all comes down to a question of interpreting the agreement. And then there's two possible solutions once you accept, if you do, our interpretation, which is that the contract certainly doesn't do that. And of course, it was the Court of Appeal's interpretation as well. I'm looking at the time.
So am I.
Yes.
We'll resume at 2:00.